Thank you, Wendy, for that introduction. And before I start, may I just congratulate you on this marvellous event. I think it's a tremendous initiative, and I'll come back to that if I might at the end. The three speakers we've heard this morning I thought were outstanding. They all managed to soar, and they certainly set the scene tremendously, I think, for what is going to pass in these 2 days. In contrast to their soaring presentations, my topic is a little bit more prosaic. I've been asked to speak about the key elements of a constitution. And when I was asked to do this, I thought I'd just take 4 bullet points and speak to them until I saw the severe time limitations upon me, so I actually sat down and prepared something slightly more structured. And I have organised my thoughts around 4 headings, 4, I suppose you'd call them, 4 key elements, which I term the logistical element, which I'll speak to briefly, the process element, the superstructural element, if I might coin that term, the superstructural element, and in contradistinction to that, the infrastructural element. Now, the last of these, the infrastructural element, the detail of the Constitution, of course, is the most important, but the other elements also need to be addressed. So if I might just start with what I term the logistical element. This element addresses the nature of our enterprise, what we're seeking to achieve here in this workshop. I note that the possibility of a formal codified constitution is within the remit of the Constitutional Advisory Panel, but it's not a given because the bullet point written constitution is lumped under the heading other constitutional matters. So if you like, the terms of reference for the panel really sees the possibility of a written constitution, a formal, entrenched one, as almost a byproduct or a flow-on consequence of the review process. Now, it's interesting because I venture that this workshop will have a quite different approach. I am taking a punt, and I would assume that you people will set out to embark upon a much more ambitious project, namely to adopt or to propose a formal codified constitution. Any lesser proposal of the constitutional change, I suggest, would be seen to be just that. It would be indistinguishable from all of those constitutional changes that we have witnessed, particularly over the last 20 or 25 years. So I suspect this workshop will set out with much more ambitious purpose and will advocate, in fact, what Peter Dunn was talking about, macro-constitutional change. Something that sets it apart from what we've experienced over the last 20, 25 years, a period indeed in which we have seen significant constitutional changes. But I think any change proposal short of a formal written constitution would be, shall I say, less than intellectually satisfying for you here. This is your chance, why squander it? So I'm really, I suppose, throwing down the gauntlet as something of a challenge. So it's important, if possible, I think, to agree on the goal of this workshop, if that is indeed our goal, because if we settle upon the idea of a formal, entrenched, supreme law constitution, then it will also resolve certain critical infrastructural issues, in particular regarding the questions of entrenchment and constitutional enforcement. Because a codified constitution, a supreme law constitution, controls everything, as you know. It's distinguished by its higher law status. So it would be preferable to settle upon the type of constitutional reform, I think, from the outset, because that will then set the agenda for all of these infrastructural issues we must look at as well. Which brings me now to the second element, what I call the process element. Let us suppose now we are indeed embarking upon this formal journey of adopting something bright and imaginative and visionary, a written constitution with ambitious purpose. How then might we adopt such an instrument? Because any such instrument which would be of this nature would have to claim constitutional legitimacy. So how might we clothe such an instrument with this necessary element of legitimacy? Now, we're not talking about an ordinary law passed by Parliament or parliamentary majority. We are talking here about the law behind the law that constitutes, if you like, the state and its system of government. So it must be able to claim legitimacy, some sort of a consensus of the people. Now, there are various methods by which states have set about to clothe a new constitutional settlement with this element of legitimacy. Some states, for example, have convened what is termed a constituent assembly of the people. And a constituent assembly of the people really is the nature of a representative body representing the most powerful interest groups within society, so as to claim this element of popular consensus and support. And there are other methods too by which states have proclaimed new constitutional settlements, and this might interest you. Some states have actually set about to contrive a legal discontinuity, a revolution if you like, so as to sever the legal past from the legal future, and then proclaim the new settlement for the future. Although I don't think anyone here has been talking about revolutionary change and revolutions to adopt a new constitution. Now, we are a unitary state, which actually works to our benefit in a way. We're not encumbered by the complexities of a federal system with different layers of government. So might we just look for a simpler method of adopting a new constitutional blueprint for the future? Might we just simply hold a national referendum of the people? And that is a viable, I think, possibility. But then there are problems possibly with that too, because we must cement a broad consensus for something as fundamental as a new constitutional arrangement. So what if we had a national referendum and we only had a bare majority of the people supporting it? A bare majority of 51. Would that be enough? And I simply pose that as a question. Perhaps that might stimulate further discussion down the track. But certainly these are process questions which will need to be addressed. How best to adopt such a constitutional blueprint? Which brings me to the third element, the superstructural element. It's a terrible word I've contrived there, superstructural, but I think it conveys what I want to talk about. And I use this term in contradistinction to infra-structural, which is really my fourth element. If the workshop promotes macro-constitutional change, a new constitution, then clearly thought must be given to the principles, values, ideals that will inform the constitutional infrastructure. When I talk about infrastructure, the detailed elements of the constitution that will in fact comprise the governmental system. And in fact, our three speakers this morning all really address this element of superstructure. What do we stand for as a country? And what should the new constitutional arrangement, how should it be organised, under what ideals, what principles, what values? Because all of these things will inform the detail of the constitution. Now these principles are often called principles of state or social policy. These principles identify, as I said, what the state stands for in terms of political or state's philosophy. And often they'll be couched quite rhetorically. The United States Constitution starts out with these marvellous, evocative, rhetorical words, we the people. And it was interesting that Jim McClay talked about the United Nations Charter, constituting the United Nations, starting out with a similar phrase, obviously borrowed from the American Constitution, albeit there it's we the peoples. But perfectly rhetorical. The preamble to the American Constitution acknowledges forming, quote, a more perfect union, unquote, that can secure the blessings of liberty, tranquility, the general welfare of the people. So these are aspirational principles which set the tone for what the Constitution will provide. So that will throw down a challenge for would-be constitution makers. What is this country's dominant ideology? Is there a dominant ideology? Might the country adhere to more than one? And at once we confront the hard questions. All would agree on one thing: we're a liberal democracy. And Jim McClay, our first speaker, spoke about that today. So we hold to representative democracy, hence this parliament here, regular elections. We have a system of independent courts, so we adhere to the principle of judicial independence. And also we uphold and adhere to the fundamental values of liberty and freedom, principles that actually define the modern liberal democracy, principles that promote human autonomy, human dignity, rights, freedoms, liberties. But most would say we're more than that. We're more than simply a liberal democracy, because that doesn't separate New Zealand from Australia, Canada, or any other modern liberal democracy. So most would say we're more than that. Indeed, that we're a country organised on the principle of biculturalism. The principle of biculturalism that is enshrined from the outset in the Treaty of Waitangi. So this just brings us then to the point that maybe we're talking about a melding of ideologies that can account for our unique foundations, the unique foundations of Aotearoa New Zealand. And these are issues which you will be exploring, I'm sure, over these 2 days. So the framers then of a new constitution would need to embrace these two ideals, liberal democracy and biculturalism. Certainly a codified constitution would entrench the elements of representative democracy. The next question now is, should such a constitution go on and entrench the treaty? Now that might be a little bit more problematic because of the reasons identified by Jim McClay, that there is not necessarily a consensus at all times as to what the treaty stands for, in terms of its detail at least. That's a question which you will be exploring, no doubt. So the superstructural element is crucial then in settling upon the ideals and values that will inform the detailed constitution, which brings me then to my 4th element, which I term the infrastructural element. And this, I suggest, is where the real bump and grind of the workshop will happen, in settling upon the detail of the constitution. Now, I don't want to lapse into a stage 1 public law lecture, but as you know, 2 features distinguish a formal codified constitution. Supreme law and fundamental law. These are 2 identifying features. Supreme law, of course, denotes constitutional entrenchment, that the constitution must be protected from ordinary alteration by act of parliament. So, a supreme law constitution then enjoys a higher legal sanctity than all other laws. Fundamental law is different. Fundamental law is constitutive. Fundamental law is the law that establishes the organs of government, the organs that comprise our system of government. So, if we're talking about a proposal now for a supreme law constitution, there are immediate flow-on effects from that, which we can't avoid. When law students walk through the portals of a law school, they're hit by a full-blown totality called parliamentary sovereignty. Well, you adopt a supreme law constitution and you immediately jettison that concept, which has been to the forefront of our constitutional arrangements as we've inherited in this country. So that's the first effect. Forget parliamentary sovereignty, Parliament will no longer be sovereign, because all organs of government will be controlled by the Supreme Law Constitution. So any law passed by Parliament would be subject to the power of judicial invalidation. Or some states have set up special constitutional courts or constitutional bodies to adjudicate on the constitutionality of legislation. But however you do it, whatever the detail, that is the reality. Now, ardent Democrats might rail against such a proposal, and this is where the bump and grind starts to happen. There will be ardent Democrats amongst us who will say that we elect our parliamentarians, we don't elect our judges. So our representatives of people must be the ones who have the final say on what is law and what is not the courts, who aren't elected and aren't accountable. So that would be one response to a proposal for a fundamental constitution, Supreme Law Constitution. And then there'll be others who counter and say, but we proclaim the rule of law. And the rule of law posits this fundamental ideal of limited government. And absolute power to these people, rule of law protagonists, absolute power is simply anathema. Absolute power can't coexist with the rule of law, which implies limited government. So these are the philosophical issues you'll be throwing around, even in this infrastructural context, dealing with the detail of the Constitution. And all times, superstructure will inform the infrastructure. So one can discern the potential for bump and grind. That said, there are certain characteristics or features which are common to all Western political systems. And the first feature is this: each is founded on a separation of powers of sorts. Now I say of sorts because different countries have interpreted this idea of a separation of powers differently. But putting aside the detail, one can discern under all modern Western constitutions at least a rudimentary separation of the executive, legislative and judicial powers. And one would assume that any blueprint for a constitutional settlement in this country would again be organised under those three branches of government. And so you might ask the question, well, why should we actually separate powers in this way? Montesquieu asked that question way back in 1748. He's the father of the modern doctrine of separation of powers, and he said, well, power corrupts, and absolute power corrupts absolutely. So the reason why you separate powers is to limit them, that one power can operate as a check or a balance on the other. And so those Madison-type devotees would actually promote the power of judicial review of legislation as a check and a balance on the legislative branch, as being part of the separation of powers doctrine. Just note, though, that in talking about a separation of powers here in New Zealand, you would have to confront, I think, a major departure from the doctrine in this country. It's a departure which identifies the Westminster parliamentary system. We're talking here about the principle of the parliamentary ministry. It was once a conventional requirement, it's now codified in law. As you all know, Section 6 of the Constitution Act, yes, I had a very sad life, I know these sections off by heart, but it says you cannot be appointed as a Minister of the Crown unless you're first elected as a Member of Parliament. So here we have a melding then, a merging, if you like, of two branches of government, the executive and the legislative branch. Just contrast that with the paper separation in the United States. Under the three sections 1, 2 and 3, we have a paper separation of powers with no merging of personnel between one or the other. So there are different interpretations then of the separation of powers doctrine. Now, in noting this major departure from the separation of powers, the question arises, would we wish to jettison this feature of our Constitution, the parliamentary ministry? And my response to that, without trying to preempt your conversations, would be I hope not, because it has worked well for us in the past and I would think it could work well for us in the future. Now, the infrastructural element might also define the interrelationships then between these organs. So, for example, the principle of judicial independence may well be codified in such an instrument, guaranteeing judicial tenure and also outlining those very limited grounds on which certainly the Superior Court judges in this country can be removed from office. Also, parliamentary privilege. The written constitution might endorse or codify Parliament's freedom of speech and its institutional autonomy, and the courts won't intrude upon those things. And another feature of a new codified constitution, one would need to settle upon an appropriate method of constitutional amendment. How might this new constitution be altered for future purposes, as needs must? Now, some constitutions, I've got in mind here the Federal Republic of Germany, stipulate that certain articles of the constitution are simply inalienable. They are simply unalterable. Now, that's interesting because one might think about entrenching the treaty. Should one declare that the treaty, being such an historic document, is simply unalterable through any amending formula? Something to think about. But many methods are practiced around the world. Most states prescribe amending formulas, amending procedures of varying rigidity. I could take you through the detail of this, it's probably not necessary, but, well, I would actually, yes. In the United States of America, constitutional process is through quite an elaborate formula. First of all, there must be a 2/3 vote of both houses of Congress, the House of Representatives and the Senate. And then any such bill passed by that supermajority must then be ratified by 3/4 of the states. So that's quite actually a cumbersome process. Contrast in Australia, where it's contemplated that amendment of the Constitution may be by simply a national referendum. It must be carried by a majority of voters in a national referendum, and it must be carried in a majority of states in Australia. Now, that's quite a simplified procedure, but it's quite interesting that seldom has that procedure been satisfied in Australia. There have only been about 8 or 9 successful amendments since the Constitution was adopted over 110 years ago. Whereas in the United States of America, we have got a very cumbersome paper procedure. There have been 25 amendments, in fact, of the American Constitution. The first 10 amendments established the historic Bill of Rights way back in 1791. So again, there's something to think about. Perhaps on this point, perhaps simply we could adopt the provisions of our Electoral Act and simply provide for a 75% majority in Parliament or a referendum for constitutional amendment. Things to think about. Now, the infrastructural element would need to address two further things, and this has been touched on by all three speakers. First of all, the role of the treaty within our constitutional arrangements, and with that, of course, the New Zealand Bill of Rights Act. Should the treaty and the Bill of Rights be included as part of the entrenched constitution? Now, these matters are contained in terms of reference of the Constitutional Advisory Panel, which will be exercising Sir Tiffany and his colleagues over the next few months. But if we're to entrench the Bill of Rights, should we not think about maybe including further guarantees, for example, to guarantee rights to private property, or some guarantee against environmental spoliation, if certain public or private actions might have a disproportionate impact on the environment? These are matters which are on the table for discussion if we thought about entrenching a Bill of Rights within a new constitutional settlement. Should further socio-economic rights likewise be included? Now, I pose that as a question, but just add this caveat. In addressing these issues, I think some idealism may need to be tempered with realism, simply because a constitution must be a workable instrument. It must be a workable instrument capable of producing stable government. Now, I think I'll probably be going beyond my time, but a couple of minutes? Yeah, okay. These workshops, as you know, or this workshop is convened with one eye on the constitutional review under the Constitutional Advisory Panel, and under several headings, you might note several listed terms of reference. Under the heading Crown Maori Relationship Matters, the question of separate Maori representation is something which has been bullet pointed. Again, it's something which you might wish to consider, whether it should be included in the codified constitution or simply left in a specialist electoral act as it now is, or whether you wish to retain it or embrace it and develop it further. These are issues for discussion. Other matters mandated for the panel which might provide a bit of a pointer for you people: the size of Parliament, the length of the parliamentary term, and if you were to extend it to 4 years, might you consider fixing it at 4 years so as to take away the Prime Ministerial prerogative to go to the country at the most propitious time. And there are other matters affecting the electoral system, number of electorates, and other matters too, which I don't think I need to mention. So that will all be part of your remit. Now, some topics of obvious constitutional importance were deliberately, one assumes, deliberately omitted from the panel's smorgasbord. And the obvious one is the head of state question. Now, you may wish to park this issue for another day, or you may wish to embrace it, notwithstanding it's been left off the panel's terms of reference. If you are genuinely contemplating a proposed new constitutional settlement, you might find it unnatural, simply artificial, to treat it as an elephant in the room, there but not there. So I think you should just take Peter Dunn's exhortation and just grab it, make it part of your settlement. Which brings me to my concluding remarks. I wish you well in your endeavours over these 2 days. It's going to be fascinating to see what you come up with. This is partly because of the nature of the exercise. What is or is not constitutionally important and worthy of inclusion is really much like beauty. It's in the eye of the beholder. So what you come up with as a collective group may be quite different from the matters I have identified in this very short presentation. But that is not important. What is important is that a group of intellectually energised, talented young people are prepared to roll their sleeves up and engage with issues of nation building. And so I do commend you, and more so I commend Wendy McGuinness for this wonderful initiative. It's a marvellous initiative, and I congratulate you.